we're back again. Kristi and Katie, your crime time friends. Stories, justice, laughs collide. True Crime Squad, come join the ride. Grab the clues, let's take a stand. For victims' voices, hand in hand. True Crime Squad, it's time to shine. Season 6, your turn, your time. True Crime Squad, where justice meets hilarity.
Hey everybody, and welcome to the True Crime Squad. This is Katie Weaver. I'm here with my sister, co-host, and partner in crime, Kristi Brower. Hello.
Hello.
How's it going?
Better now, man. My head was just reeling after today's court. Holy shit.
I've never seen anything like today's court.
Right? And there were so many moments of that.
So many
different moments of that.
Yeah. So this was day 2 of the defense, presenting a defense, as is their right. But if you thought the defense was a shit show yesterday, you were not ready for today.
They said, hold my beer.
First of all, apparently, they thought that calling witnesses just meant calling every attorney that's ever worked with the Adelson family, which was a very odd choice.
I have never seen this many attorneys testify in a trial before, ever.
Me neither. And they chose to, with the first 2 witnesses, to attack the victim over and over and over again, which I really wondered how that felt to the jury. But the very first thing, Josh came straight out of the gate this morning, kind of accusing the defensive or the state of fiddling with one of his witnesses. And then he really backed it up. He's somebody got to her. I'm not saying, I don't know. I'm not saying who did it, but he was insinuating that the state had meddled with one of his witnesses. But here's the problem. She wasn't one of his witnesses. This person had never been subpoenaed. He was way late to the game. So let's listen to how this went down, because it'll give you a pretty good precursor as to the belligerent turd circus that marched on throughout the entire day.
Yeah.
I'm not accusing the state attorney's office of doing anything. I'm merely advising the court what transpired. Mr. Campbell advised that when somebody from the sheriff's office went to speak with this officer, the officer expressed to that superior that they were no longer willing to speak with us. And was no longer available, in fact, that the officer was going to be on leave.
Well, we can bring in Under Sheriff Google, however, at this point in time, this does not invoke the court to need to go through a Richardson inquiry. The witnesses that you're referring to, have they been disclosed to the state?
It's not by us, Your Honor, because again, we have not had a chance to speak with her.
Do you intend to call these individuals?
If we can confirm the information.
These are not answers. If you're not actually intending to call a witness that has not been previously disclosed, at this point, I do not have to engage in a Richardson hearing on this matter. But as far as witnesses that you may be investigating or you may speculate have relevant testimony, until you disclose them, until you actually intend to call them, there's really not much I can do with this. If you wish for me to hear from the Under Sheriff, I will. But as far as perfecting a subpoena and speaking to these people who are either not under subpoena or not listed witnesses, there's not very much I can do.
Judge, it is the defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense. We are asking for the court's assistance because the rules...
To do what exactly?
So that we can at least speak with her to find out if she has anything that's admissible.
The court has jurisdictional authority limits. For someone who is not under a subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the Under Sheriff. He can speak to these matters that you've raised.
Thank you, Your Honor. Judge, if I may, whatever happened after we spoke with the officer yesterday afternoon, even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the timeliness of the witness itself and the fact that it's occurring in the middle of trial. But that part of it, again, these are certain things I cannot assist with. And the Sheriff Google, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give to be the truth?
Yes, sir, I do.
If you can just stand in front of the court reporter instead of taking the witness stand. If you can explain to me what occurred with, I believe this is one of the correctional deputies that may or may not have testimony concerning this case. Please explain what happened with them to the best of your knowledge.
To my knowledge, I was approached by Captain Georgia Dent, who had spoken with Deputy Franklin, and Deputy Franklin informed Captain Dent that she had received a phone call from inmate Addison's attorneys, and they were advising her that they were going to be at the detention facility later that afternoon, which was on yesterday, and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so choose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with General Counsel, I spoke back to Captain Dent, and she relayed that information to Deputy Franklin.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defense?
No, sir.
An examination for under Sheriff Google by the defense or state?
Not from the state, Your Honor.
The state's like, we don't want anything to do with this.
It is our understanding that Officer Franklin is now on leave and is not available to be served.
That's not my knowledge. I have no clue about that.
So she is available to be served?
I would think so. I'm not aware of her being on leave.
Thank you.
Yes, sir.
Sheriff Google, there is no more inquiry that I will make of you concerning this topic. I appreciate you being here this morning.
Yes, sir. Thank you.
Concerning the other witness, who is not the guard, was the defense able to make contact with this individual?
All right. So essentially, and I know this is hard to hear. The courtroom audio has not been amazing. Basically, what happened is that yesterday the defense got some idea that there was a deputy working at the jail who might have some interesting information for them. And they made a call over there and basically said they were going to be coming over to talk to this person. And so her supervisor spoke to their supervisor, and basically they talked to the jail's counsel, and basically they said, yeah, if she wants to speak with them, she can. She doesn't have to. There was no subpoena.
Right. She's also not on their witness list.
She's not on their witness list, so they were going to try and pull something this morning and sneak her in, or find some way to make this happen. I mean, this was a huge Hail Mary because she's not on the witness list, meaning the state has not deposed her. So
Right.
they couldn't have put her on the stand unless the state had had an opportunity to speak with her. Like, it probably wasn't happening anyway. But
Right.
for whatever reason, she decided, no, I really don't want anything to do with this. I don't want to talk to them. And maybe she just, I'm sure there's a lot of reasons why, but for whatever reason, she decided, nah, unless there's a subpoena, I'm not talking to them.
Yeah.
Partly, you have to understand, Donna is an inmate at her jail. There's
Right.
lots of inmates at her jail. And without a subpoena, you're probably not just running around talking to their defense attorneys, because that may not be very good for you as far as your job is concerned, and, getting other inmates to cooperate with you. And I would imagine there's a lot of reasons why. We don't know exactly
Sure.
why. Josh tried very hard to insinuate that somebody had got to her. And they started the stream today after he'd already spoken for for a short amount of time. He had already started in on the judge that someone had gotten to her and insinuated it was the state. And the state was like, whoa, whoa, whoa. We haven't done it shit. And he was like, that's when we started the video. And he says, I'm not saying it was the state. Only, who was it then?
Yeah, he was trying to real hard.
Mm-hmm. But that's how they got off. That's the foot we stepped out upon first thing this morning.
Not great.
They'd also made a request of the judge that they take today completely off in order to let their client rest and prepare her for potentially testifying. To which the judge said, absolutely not. I will give you a little bit of a longer lunch if you need to prepare her, but that's what's happening. We are going to go on today. He let them out early yesterday because the defense needed more time.
Yeah.
So today he's
That's
like, nah.
All they've done is need more time. It's like
Mhm.
it's like John Pryor all over again.
Yeah. Yeah. So then we start the day with the first witness, who is Kristen Adamson. It's very confusing because her last name is Adamson. Every time Josh says it, it sounds like he's saying Adelson. It's extremely confusing, but that's an aside. Kristen Adamson was Wendy's divorce attorney. Wendy had stipulated that Kristen could come and testify and share details of her divorce. That's why she was here. So we're going to listen to a short clip from her. I will say that Kristen and then the next witness disparaged Dan consistently throughout their testimony, and I thought that was a very strange choice to make in front of the jury.
Right? Talking shit on the victim? Why would you do that?
Mm-hmm. I don't know, but let's take a quick look at Kristen.
Happened with Wendy Adelson's relocation.
She did not win her relocation.
Can you tell us what happened at that hearing?
So we had a hearing on the relocation. We put on Wendy Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on the lawyer from the law firm that had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that, and then at the end of our testimony, the judge asked to speak to counsel, which happens a lot, and she took counsel out. It was me and Professor Markel's lawyer, and she told us she understood why Ms. Adelson wanted to move. But she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
During that hearing, or after the judge made those comments, did Wendy go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendy about that, and then Wendy's parents were there, and I actually spoke to Wendy and her parents, and then she went and spoke to her parents again, I think, if I can remember. It was a long time ago, but I think she spoke to her parents outside of my presence as well.
Did Wendy ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
So what happened at that point was we went back into court. The judge denied Professor Markel's motion to dismiss, because he had filed a motion to dismiss our pleading. She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point in time, I believe it was approximately the third week of June of 2013?
Yes.
Okay. And what was Wendy's reaction?
At that point in time, I think she was upset that she wasn't going to, and nobody wants to not win their case. She was upset. She was always calm during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak a few times after that because we had to get geared up for the next round of this. We had already gone to mediation before that, and we had not been able to agree at the mediation on the relocation. So we knew we had to go to another mediation. So I talked to her several times about the next mediation, which would be dealing with all the other parenting issues and the financial issues. So I did talk to her quite a bit after that, and she seemed resigned to it.
Now, although the court denied the petition, would it have been possible for Wendy Adelson to offer Mr. Markel any financial incentive in order to convince him to change his mind?
Well, we hadn't finished the case. We still were going to go to another mediation. It's always possible. I tell everyone that even after an unsuccessful mediation, people settle their cases on the eve of trial all the time in some way or another. They do. And it's always best if you can settle your case and not leave it to court. You have much more control if you are the decision makers rather than the court.
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No.
I mean, I'd argue yes, but okay. It's kind of gross to me, but whatever. But that is a taste of Kristen Adamson. She really, really downplayed Wendy's response and Donna's response. And an interesting fact, and I couldn't find it here, unfortunately, but I'm going to share with you. One of the things that happened is that you guys remember back when we saw the emails, what was happening? Wendy would receive an email from her attorney with a filing or with a whatever. She would immediately forward it to her mother. Her mother would type out all this stuff, all these questions or bullet points or demands or whatever, all of her thoughts. She'd send it back to Wendy. Wendy would copy and paste it into an email to her attorney and send it to her, right? We saw this happen multiple times, right?
Yep.
Kristen Adamson completely denies that, which either tells me that she didn't know that was happening, and maybe she didn't, because the emails were coming from Wendy. But she seems to have no idea how involved Donna actually was in Wendy's divorce. But I will say Kristen also said that Wendy wasn't all that involved in her divorce. that
Yeah,
she wasn't really. I mean, Kristen took the lead, and I mean, Wendy had a few requests here and there, but she really wasn't all that involved.
and she writes all her own briefs, don't you know? And she made this
Yes.
really big deal about it that
Mm-hmm.
made it. I didn't. I felt like she was being dishonest. Honestly, I really
Mm-hmm.
did. I
Mm-hmm.
felt like she was lying.
Well, they were very busily putting lipstick on a pig over there. That it was all sunshine and
Mm,
butterflies, and this was a very routine divorce, and it wasn't contentious at all, and everyone was so
right.
happy. And then she'd have to say something like, "Okay, well, yeah, they were. She was very upset about this, but then she was fine, and everything was wonderful." And it was pretty wild. It was weird to me to hear from Wendy's attorney, for one. But one of the big points that the state had made was that Donna was controlling Wendy's divorce via email. And either Kristen didn't know that or she lied about it on the stand today.
Yeah,
Because the emails prove that.
they do. I don't know if y'all have noticed, but Sandy has found a way to still be sort of on my shoulder. She's
Oh,
just a little further back. If you
how
can see her
funny.
there. Isn't that funny?
She's found a new spot.
I wanted to answer a question that somebody asked about, are Jackie Fulford and Josh Zellman partners in a law firm? No, they're not. They have their own. I don't know if they've ever worked together. Maybe they
Interesting.
have. Zellman, actually, he is a criminal defense attorney, but he specializes in DUIs, guys.
Really?
Did you
Wow.
ever get the impression that maybe he wasn't all that familiar with murder trials? Because I kind
Yeah.
of had.
Mm-hmm.
Well, I mean, he is a criminal defense attorney, and it may not be that he's never done a murder before, but yeah, no, these two don't work together. They're not in the same firm, and Josh is considered second chair
Right.
in this. But did he seem like second chair to you guys?
Well, he's done most of the work, but have you seen Jackie over there?
Yeah.
Jackie
What the
looks
hell is
stoned to the
Jackie on?
bone most
She
days.
does.
Yeah. This has been the
Yeah,
wildest attorney combo I think I've ever seen.
it really has. But I had wondered, like, I don't think these guys like know each other and have worked together a lot or something.
I
I'm
wonder if
pretty sure
Josh
they
is
have.
going home at night going, never again, Jackie.
Oh my God, right?
I really wonder.
Maybe,
Yeah.
but he's been wildly unprepared himself.
Oh, very much so. Yeah, very much so. Yeah. There was a moment today where, and it's down the road in this, but I'm going to mention it now because it's in my head. But there was a moment where, because Josh basically did all the work today, you know, and they had already asked the judge for more time so that Donna could decide if she was going to testify. And then he said that Miss Fulford wanted to have a word with the judge. So he's like, okay, what? And then she tried to have a word with the judge about them needing more time for Donna, as if somehow she had some kind of sway or that the judge would really listen to her. And he was still like, next. Yeah.
I'll give you 5 minutes.
Mm-hmm.
He
Yeah.
actually did that twice.
Mm-hmm. Yeah. So then we come into an unbelievable situation that felt like deja vu from yesterday. Tell us all about it.
Well, turns out that the next witness, her name is Linda Bailey, was sitting in the gallery while Kristen Adamson was testifying again. Okay, so ridiculous. But okay, you have to hear the judge handle it because honestly, he literally just handed Zellman's ass to him repeatedly today.
Mm-hmm.
And let's just hear what Judge Everett had to say.
Yeah.
From the presses from our very capable court reporters, has everyone reviewed the transcript at this point?
Yes, Your Honor.
Please make your argument.
Judge, I mean, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zellman.
Judge, on page 62, we specifically.
So they're reviewing a previous filing that is about the experts can listen to other experts if they're sort of like they're going to testify against what that expert said. They can hear what they said, right?
Mhm.
We know that's a thing, right? So in their mind, then it's okay for Linda Bailey to be in the courtroom with when Kristen Adamson is testifying.
And just so you know,
Except-
these women are like BFFs. They went to law school together. They have both been attorneys for 37 years in Tallahassee. They work together and know each other very well.
Well, Linda Bailey referred to Kristen as Kristen over and over and over
Yeah.
again, calling her by her first name.
Mhm.
So this is what they're arguing: is what did the state agree to this?
Mhm.
So let's take a listen.
They said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies, and then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Y, to be able to observe witnesses. We were not asking for that.
As to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now. Why should this witness be permitted to testify, Mr. Zellman?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything but an adverse expert as to an observation of testimony that would otherwise go to the rule of sequestration.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened, though, is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's, this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration. When this was addressed at sidebar, you brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual, or even brought up this topic to make sure we did not end up in this point and place?
Judge, we thought we adequately addressed it last week during the sidebar.
Ms. Kaplan, what are you asking for?
Seeking exclusion, Your Honor.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses that are experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy, but you did admonish the defense to not let it happen again, and now it's happened again. So, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated, I think it's appropriate, so.
As to your point of the state being a fair trial, Ms. Kaplan, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may.
No, you may not. Shut up, Josh.
Just
Exclusion of the witness. Court may exclude witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
This is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness stand so that Crawford can be taken.
okay. I won't make you listen to that because, frankly,
Yeah.
boy. Oh, whoops, sorry. Okay, so they bring her up, question her. She literally says she wanted to hear Kristen's testimony, not Ms. Adamson. She says Kristen over and over again. You can really tell that there's some weird collusion between these two people because she wanted to make sure she got the facts straight. You're
Right.
supposed to be the expert. What the hell?
Yeah.
The judge eventually does allow it, but I think was probably real fucking sorry he did, considering
yeah.
all the bullshit that went on with her.
Yeah.
It's so stupid.
Including a sidebar because she starts rolling out this enormous amount of binders and a big box and all this stuff, trying to talk about a different case that she's involved in and how contentious it was. Trying to just show how this was just not a big deal. She was so incredibly cold-hearted, unbelievably arrogant. I do have a clip that we'll watch, and then I know, have the cross that we were all dying for. So we'll watch a little bit of her on direct. But she acted like people getting divorced every day, all the time, is just no big deal at all, and people should just get over it. And it's just nothing.
Yeah.
Yeah, the
It
fight
was
about the
so
$80,000. $80,000 is not that much money.
Oh, yeah. I've got all of that. Georgia was ready to murder her. I tell you what. It was so gross. And all of it just to say that this really wasn't a contentious divorce, guys.
And it was just no big deal. It was just no big deal. Yeah. So we'll watch a little bit of her on direct, but then we'll watch The Cross is better. So
You testified earlier that you reviewed emails between my client and her daughter.
I did.
Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No. We have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you reviewed, did you see my client's use of the nickname Gibbers to refer to Mr. Markell?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markell's motion.
That's funny because that's not what Wendy said, is it?
Sure isn't.
It's just a funny name. My friend helped me come up with it to make him not so terrifying, Wendy.
Right.
Fuck off. But yes, this is the clip I chose because I wanted you to see the way she speaks about Dan. And this is pretty typical to the way Adamson speaks about him as well as Bailey.
and memorandums and responses he filed in this case. It was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendy Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph that he knew she had these accounts because he managed one of them, and he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy.
But see, she slips a little there because she inadvertently does admit that Wendy was not being forthcoming with her accounts. One of the things that kind of comes out quietly today are all the difficulties Dan was having with Wendy. All they want to talk about is how difficult Dan was, Dan was trying to stipulate for things and trying to enforce things and agreements he and Wendy had made because she was breaking them.
Right.
She was breaking them. Now, Dan did some things too. I'm not saying he's innocent. He only gave her a portion of the money he was supposed to give her and was withholding the rest of it because of some of this stuff that she'd been doing. I mean, I don't know. To me, that sounds, dare I say, contentious.
Right?
So let's go on and listen to what we were all really hoping for in the chat today, and that was that Georgia go ham on Linda Bailey's ass, and boy did she. Probably the best cross of this whole trial.
Yes. So do you want that now?
Yeah, let's do it.
Oh, okay. We need to say hi to Mr. Cherish because he's listening for the first time. So welcome.
Well, hello.
This is honestly... This was a very satisfying cross-examination because everyone was so irritated with this woman.
I was cheering.
And she was just shitty. And then Georgia got up. And we knew she'd hit it out of the park, and she did.
To review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason-
that? Do you agree with that?
Ms. Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree. That's one reason I called Kristen, is Ms. Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get emotion. If I get something, for example, that, although I've never had, something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to ID.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question. You were asked.
You're getting owned, Linda.
Let's go on to something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law litigation?
I've never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey. To
Right,
that
Linda.
person, it was a reason to commit suicide, right?
Apparently so.
Welcome to the party, Linda.
Mm-hmm.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal, it wouldn't be granted, it was buried in there. But the allegation is, grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't know.
Exactly.
It shouldn't have been. There was no proof,
It should have been in your opinion.
in my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
This woman drives me insane.
Mr. Markel wasn't paying by the deadline.
That was to Linda Bailey,
Isn't that
not
something
you
that would
guys.
be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Exactly. So we'd have
What?
to party, right? Right?
Sure.
Okay.
You know, I think on that issue, he clearly had the asset, so at the end of the day, he was gonna pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was gonna end up in jail.
Okay, well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And
I
Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is, you go to jail.
No, that's not true.
It's not true. Okay. Ms.
Yeah.
Adamson was incorrect on that point, I guess.
Objection, Your Honor, no question, I need to strike.
I'll
What is
rephrase
the-
it.
What
Was
is the objection again?
It's an improper comment on the witness's testimony.
Go ahead and please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st.
Just yes or
One
no.
was the $70,000 still due to Wendy. Jail is not a possibility on that. You don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support, and if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever, and then all of a sudden he comes up with money out of his pocket and he pays, he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. There's no jail consequence to the $70,000 due Wendy. It was only the $10,000 due Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see, in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendy then forwarding those answers to her mother?
I don't recall that.
Of course you don't, Linda.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided After the flurry, right after the relocation, before the final judgment was entered in July of 2013, after July 2013, I don't recall seeing any emails from Miss Donna Adelson about the relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
Obviously.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law, and I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud, and it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well,
would have been shorter if somebody gotten murdered, wouldn't it, Miss Bailey?
if there wasn't a party, the case would have ended.
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case.
It
Yes?
was.
Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Objection or false speculation.
Overruled, the witness has provided an opinion, the state
Well-
will cross-examine.
I guess my
It's-
response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th and had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But
So
that hadn't happened yet.
it had not happened yet.
And we'll never know when that was going to happen because we never got to that point, right?
Clearly,
Because he was murdered.
clearly.
May I have a moment to confer, Judge?
Yep.
Boom!
Oh
That is the most tedious human being I've ever seen in my entire life.
my
Oh
gosh.
my God.
No, but Georgia played her well. And in fact, by the end, had her
Georgia
agreeing
did
to
play her well.
a lot of things that she wasn't willing to agree to in the beginning. But my thought was this. If I'm on the jury and I myself had been through a really painful divorce, or my
Right.
parents have, or my sibling had, or one of my children had, this was a trigger from hell. The way Kristen Adamson behaved, the way Linda Bailey behaved, the way she was making light of divorce and, that it's not upsetting and people are fine, and just her entire
$80,000
jaded
isn't
behavior.
that much money? Are you
If I had been
fucking
on the
kidding me?
jury, yeah, I think I would have felt very triggered and affronted by the way she behaved. Personal opinion. But larger opinion from both of these two, what the hell did the jury learn from any of this? I feel like it was better for the state than it was for the defense.
Right? Did they learn from all that this wasn't a contentious divorce? I
No,
don't think they did.
no,
No.
they didn't. But also, in the defense's opening, they claimed that the grandma filing, right, was just a big nothing burger, and the state has completely misinterpreted that, and that's not what it said. But it is what it said, because they got Adamson and Bailey on the stand today to confirm that that is what it said, that Donna was saying bad things about Dan to his grandchildren, and he wasn't going to put up with it. That is what was said. They completely
And that
lied about that in their opening.
supervision came up.
Yes.
Yeah.
He also wanted the first right of refusal, which I don't know why he didn't have that in the first place.
Right.
But all of this is wild. Today was just...
How this was defense of Donna Adelson? Not a clue.
None. So then we get into lunch. So they take a super long lunch so little Miss Adelson can decide whether she's going to testify or not. And they come back from lunch, and who do they put on the stand? Another attorney. That was the whole day.
What is this? Yeah.
That's all you can get? So this was Donna's initial attorney before she was arrested and briefly after she was arrested. They were also supposed to have Sarah Newhouse with the Tallahassee Police Department. Never saw her.
I don't know who that is
Nope.
or why she was supposed to be there.
So then we have Marisel Descalzo. She was briefly Donna's attorney. So we're going to hear a little bit from her.
Donna Adelson.
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
And I want to direct your attention specific to the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
Okay. During that time period, when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
concerns about Mrs. Adelson's mental state, yes.
Yeah, can you tell us what those were?
She had made numerous statements about terminating her life if her son Charlie Adelson was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting is putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, you know, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Okay. At that point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest?
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson, so I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Okay. Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
Okay. And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making the serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor. Nothing further, Your Honor?
Cross-examination.
Yes, sir. Hey, good afternoon.
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But, so it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended, is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to, I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay. And you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago?
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict.
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Miss Adelson was suicidal?
Of course I didn't. No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay. Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not, I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you?
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going.
Okay.
And it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country,
Yeah. Was that good for the defense?
I don't think so.
Asking for a friend who says, no, it wasn't. Because
Just
Donna
more-
said that her attorney said that she could go to Vietnam because there was no warrant. The way she yelled at the police, she really misrepresented what her attorneys told her. They
She
said,
did.
you can try, but you might get arrested at the airport, which is indeed exactly what happened.
Well, and yeah, I didn't believe that either of those attorneys would have told her that, because
Mhm.
they're not going to get their own asses in trouble over
No.
this, you know.
No. Yep. And that
And
woman
true,
was
Linda,
only...
she
Go
did
ahead.
answer the actual questions. Linda's saying this one was better because she at least answered
Mhm.
the questions, and she did.
Well, and she was only Donna's attorney for a minute. She doesn't
Yeah.
have a lot to share. That was pretty much it for her. And then Rashbaum took clear over and was her attorney up until the time that she was supposed to start trial last December. And the night before trial started, the state said, wait a minute, Rashbaum's defending her. He also defended Charlie Adelson. Has Charlie signed something stipulating that it's okay with him to waive his rights for his attorney to also represent his mother? Turned out no. So they said, well, we got to go talk to Charlie though then and get him to sign something. And Charlie said no. And so then Donna sat in jail for 9 more months waiting for this trial while new attorneys got caught up. And I don't know if there's just no attorneys left
Well,
on the
and
planet of
isn't it-
Earth, but this is who she got.
Isn't it her attorneys that she lost a couple also because one of them burned his house down and he was married to the other one?
No, that was James Craig.
Is that? Oh, that's James Craig. Oh my hell! All these terrible people. I can't get them. Can't keep them separate. That's right. That was James Craig.
Yep.
Although it seems like something that would happen to Donna Adelson too. So.
for real. So that was what the state had, or the defense had. So the judge is trying to, like, are you going to arrest? What are you going to do? So this is where we get into decision time. So talk to us about this.
Well, the judge is like, okay, well, we gotta know, Donna, if you're gonna be testifying or not. And he had sworn her in earlier to make sure she was okay with her own attorney, testifying. And then he's like, well, we gotta do it. And they just kept, can we have 5 more minutes? Can we have more time? We just need more time. This just isn't enough.
You
And the
could
judge
almost
is
hear
getting
the Jeopardy music.
really, and the judge was getting fucking done with this shit.
Irate. Yep.
Yes. So here is what finally did happen.
If there are no other witnesses for the defense, it is time for the decision to be made.
I can tell the court that co-counsel and my client are deep in conversation. I'm sorry,
I
this.
am capable of seeing that, Mr. Zellman. No nomination is needed. Mrs. Kappelman wants the defense rest. Is the state intending to place or put on any rebuttal case?
I think not. If they arrest without calling any further witnesses, that could change if Mrs. Adelson decides to testify.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of that.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss, or have you been able to discuss with your attorneys the 2 rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
Judge, since I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
Mrs. Zellman, Ms. Fulford, Mrs. Adelson, the extra time.
Before we get there, please note, someone saying that, this is the biggest reason for appeal. I don't know why it would be, honestly. They ended early yesterday to give her time on this.
Mm-hmm.
They gave her an extra long lunch break to think about this.
Mm-hmm.
She had a 3-day holiday weekend. Also, she's been in jail for almost 2 years. So Donna has had plenty of time. This is nothing but a delay tactic. The judge hasn't done anything wrong here. They have to answer this question. Every criminal defendant does. So giving them more time, even to tomorrow,
Yeah.
what would it accomplish that they haven't already had time to do? Really?
Yeah.
Because they really literally tried to have the entire day off today.
Yeah.
And not even do any of this for that, so that they had more time.
Yeah.
But I mean, come on. So here's what happens.
Time that you have been provided that has come to a conclusion. We are not finished with the colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify. What is your decision concerning these two rights?
This time I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out.
At this time. Babe, this is the time. The only time.
I know, she said that like she had more opportunities, and she just doesn't.
Mm-hmm.
Thank you very much for the super chats, you guys. And it is Thankful
Yeah.
Thursday, and if you can, it's appreciated. If you can't, we love you anyway.
Oh,
But
yeah.
it is appreciated. This has been a wild couple of weeks.
Oh, thank you, Kristi. Yeah. Oh, my goodness, hasn't it?
Oh, it's not Thankful Thursday. It's Wednesday. My God. This trial is... Anyway, thank you.
It's ruined you. It's ruined your brain.
Okay. Listening to that Linda Bailey today, I seriously... That's what...
That was tough. Holy moly. So, then they give them the rest of the day off after that. So,
Well, sort of. First, they have to argue over the planners.
yes.
Then they're strung. Now they're like, they're in this flurry of, oh my God, do we rest? Do we not rest? Do we call someone else? What do we do?
Yes.
And the judge is like, do you even have someone else to call? Like, come on.
Right.
So they have a big argument over letting in a couple of Donna's planners to make the record complete, because that's going to change everything.
Well,
Not.
my take on that is they were trying to get back at the state because they tried to show a partial video with one of their witnesses today, and the state was like, yeah, the rule says that the whole video has to be available to the jury. And so then they're like, oh, well then what about the planners? And it was about the stupid dishes and the shit that she wanted to sell. That after they had decided to go to Vietnam, she was trying to make Wendy come over and sell a bunch of her stuff, right?
Yeah.
Wendy, who was like, new phone, who this? I don't even know you,
Yes.
you people, right?
Yeah.
So then some of her dumb friends were roped into that. Well, they're saying that in her planners, it goes clear back to 2019, making notes about wanting to sell those dishes. So that should be on the record for the jury to know, because that wasn't really happening.
Because this is really about the dishes.
Why, Josh, didn't you bring that up on cross? Why?
Right.
When the planners were brought in, when those entries were discussed and shown, when they talked about this is happening, why didn't you bring that up then? Why? Because now he's trying to tell the judge that they have to let all those planners in their entirety, because that's the completeness of the record. That's only fair, and it reaches back to the video incident earlier in the day. The judge is like, the law doesn't apply equally to those things, so they tabled that. The judge was going to investigate that and decide what the correct answer was.
He'll let him know. Yeah.
Mm-hmm.
It was super dumb, but it was this big flurry like, oh my God, this is so important.
Mm-hmm.
Except it really isn't. It's not.
Yeah.
No one cares. The jury is not going to care about those stupid planners. The poor jury has had to come and go out of that room so many times today.
Oh, man.
That
they got their steps in.
They really did. I felt bad for them. I'm sure they were like, what in the fuck is going on in here?
Mm-hmm.
You know? And some of you were saying maybe Donna can change her mind in the morning. I don't know if she can. The defense rested. They're done.
Because I think that until closing arguments that she can change her mind.
Mm.
That's my understanding, but...
I mean, I'm not opposed to it. I'm not opposed to seeing Georgia kick her ass all over that courtroom. I would take it.
This would have
very
been great.
satisfying to watch it with Linda Bailey, so let's see it again. Sure.
Mm-hmm. Let's see how long she can keep up that sweet little grandma facade.
Yeah.
They did rest in front of the jury, yes.
Mm-hmm. They did rest in front of the jury.
Mm-hmm.
So, I don't know. They kept saying stuff like, there's just been so much evidence presented in this case, and we've got to go through all of it with her. And I'm like, she's been sitting here the entire time. She knows what evidence has been presented against her. She was actually there. So what the hell? Just nothing but excuses and whiny bullshit.
Mm-hmm. Yeah. Pretty much that. So that's where we are. That's what happened. So they did talk about jury instruction. So tomorrow, the jury will receive the official jury instruction, and then we will hear closing arguments, and the jury will start deliberating. That's where we are.
Yep.
So on that note, tomorrow, could we have a verdict tomorrow? Technically, yes. I'd be super surprised. I'm guessing it'll come on Friday, but
I am too. By the time they go through, each side is given 2 hours for their closing, and you know, it might take an hour to get through the jury instructions, so that's 5 hours. So that's clear after lunch break before they're actually done. So yeah, I doubt that we'll see a verdict tomorrow.
I'd be very surprised. I'd be thrilled to pieces because we're going camping on Friday.
Yes, we are.
And when we get to go camping really depends on what happens with this trial. And I know it's not all about us all the time, but you know.
But it kind of is.
It kind of is.
Yep, there's Miss Sandy. She's just now doing her statue pose behind me.
Yeah, Charlie took 3 days, so it could take longer. Maybe they'll deliberate all day on Friday and go home for the weekend and think it over.
It's possible. It's certainly possible. There's a lot to go through. You know, I don't know. How badly do they want to go listen to all those phone calls again?
They don't.
They don't. No one does. Hearing them all once was bad enough.
Indeed. Yeah. So that's where we're at. So we will be back in the morning. Yeah, they're starting at 9 tomorrow, which is 7 our time. So we'll start the stream at about 6:45 just in case, because, you know.
Yeah.
Drama. It happens first thing in the morning with this court every time. So we'll be a little early for that reason. And we'll see what tomorrow brings. So the super chat is on. Really appreciate the tips. You can also tip us over at truecrimesquad.com on our Buy Me a Coffee. Thanks, you guys, for being here with us. We appreciate you all very much. Like, share, follow. That helps us immensely. And, you know, hopefully we can wrap up Adelson this week and move on to other things next week, because there's all kinds of things going on in the true crime world right now.
Right? There's so much stuff I want to talk about, but we can't until it's done. You know how it goes.
For sure. But I do have to say this. I'm really glad we covered this trial in its entirety. This has been very worth it. Yeah.
It has. Most definitely.
Very worth it.
Most definitely.
All righty. Thanks so much. This has been yet another production of the True Crime Squad.
Bye, everybody.
6, we're back again. Kristi and Katie, your crime time friends. Stories, justice, laughs collide. True Crime Squad, come join the ride. Grab the clues, let's take a stand. For victims' voices, hand in hand. True Crime Squad, it's time to shine. Season 6, your turn, your time. True Crime Squad, where justice meets hilarity.